what the court should hold. We agree with Chief Judge Pryor that the common law is very clearly on our side, virtually unanimous outside of Rhode Island, and we are left still wondering what the statutory hook for reading the indications of innocence standard into the statute is. I heard policy arguments from my friend on the other side. I heard arguments about kind of nose counting state courts, which, by the way, in their briefing, they only still get to a minority. We think it's far fewer than 20, but even on their own terms, they only get to 20. And the choice is between a clear rule that was developed over centuries at common law and is categorical, or a rule that requires federal courts to hold these civil mini-trials in which they are looking for something that courts don't even know what it means. It's quite extraordinary, right? Federal courts, circuit courts, lower courts usually just understand their task to be to apply the precedent. In this instance, we've pointed to a number of panels of federal judges and district court judges who have said, we have no idea what this thing means. We're actually just going to skip the question entirely. In the Southern District of New York case we cite, the court says, we're actually just going to go straight to trial because I don't want to decide this question and get into the sticky issues unless I really have to. We think that's pretty extraordinary. We think the court should adopt common sense that a criminal proceeding terminates in favor of the prosecution when it gets the conviction that it sought. A criminal proceeding terminates in favor of the accused when it doesn't. If there are no further questions, we ask that the court reverse and remand for further proceedings.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
All right, so there you have it. We have brought you 2 oral arguments this morning on cases before the highest court in our country. Thank you for being with us here on Court TV Live. I'm your midday host, Julie Grant. We've been watching along here at our studio as you have been at home at these arguments. This is the second 2 cases just wrapping up. There will be more tomorrow. We'll bring you those as well. We do have quite a jam-packed show for you with several things, but just to kind of unpack and touch on what we saw today, let me bring in one of our guests standing by for us. Trial attorney Arick Fudali is with us. He's a civil rights attorney. That's what he practices now primarily. Also formerly served as a prosecutor. Arick, welcome to the program. Thanks so much for being with us here on Court TV Live. Tell us, please, what jumped out at you in these last set of arguments that we heard? Anything in particular you think is important for our viewers to be thinking about, please?
Absolutely. I thought that last argument was very interesting, and it's sort of a fundamental constitutional issue here. What does favorable termination mean in the context of a criminal proceeding? And it's sort of a complicated question because when you look at what in a criminal case, a criminal trial, the burden is not on the defendant to show innocence. The burden is on the prosecution to show, the burden is on the prosecution to show they were guilty. So the requirement that a civil plaintiff would have to show that the prosecution demonstrated his innocence is kind of a far-fetched concept for me to grasp. And so I think that's a really interesting question if the Supreme Court decides to take it on. Certainly it seemed like the respondent in that case wanted the Supreme Court to avoid that question because ultimately I think the respondent knows that is unlikely the requirement that a favorable termination means you have to show that your innocence was in a way proven, because that would eliminate a claim where a case was dismissed for any number of reasons and also require that you get into the mind of the prosecutor as to why they ultimately dismissed the case.
Yeah, a really great point you made, Arick. And when we think about how this originated, we're talking about from Mr. Thompson's, standpoint that this is a civil rights violation at the end of the day, that his, rights were violated, and that's how we wound up getting, to this point. And he's saying that there was a malicious prosecution that ensued. And so talk to me about that, your experience. I would imagine you probably do some of this kind of work day in and day out. Is this something common that you see?
Unfortunately, it is. You do see, especially marginalized groups and minorities, charged, with malicious prosecution, without evidence or fabricated evidence. You see all this time this resisting arrest charge, when technically there shouldn't have been arrest to begin with. The arrest is unlawful, and then they ultimately charge resisting arrest. So unfortunately, you do see that a lot. But the ultimate goal then for a criminal defendant whose rights have been violated, who is being prosecuted maliciously, the ultimate, positive result would be a dismissal of the case before it goes to trial. So for that dismissal to be a way that negatively impacts the civil case from malicious prosecution, at least, perhaps it's just the perspective of a civil rights attorney here. That just doesn't seem to make sense to me.
Mm-hmm, right. And the allegation was that, he faced that prosecution after asserting his constitutional rights. And the police officer in this case is this Officer Clark. So this case really has, brought forth many different issues, right? When we're thinking of a 1983 action, and that's actually something I should probably ask you about. We hear that term thrown around. I know you know what it is. You're in court day in and day out dealing with these things. But for those who hear that, rights pursuant to 1983, what is this? What do those numbers mean? Would you explain that, please, Arick?
I'll do my best to put it as simply as possible. And it's basically, it coincides with the Fourth Amendment, which restricts or makes illegal an unlawful search and seizure. That's really where it starts. Then that gets in, of course, the malicious prosecution. So it's a deprivation of rights. It is unlawful search and seizure. It is a police officer breaking into your home without probable cause. It is an unlawful, stop, a traffic stop because they don't like the look of the person driving the car. That's where a 1983 claim comes in. Of course, it's a lot more expansive, a lot more complicated than that. But where we often see this sort of constitutional issue is in those types of cases. So, stop and frisk, which you hear a lot, without probable cause. Breaking into a house, searching a car without probable cause, those sorts of things. And of course, arresting someone without probable cause. Those would all fall under this type of claim.
Right. And just to go back to the facts, because these oral arguments are far different than what we typically broadcast day in and day out. We're really getting inundated with the stories on CourtTV of the various trials, the facts. Here, it's so heavily focused on the law, on procedural precedent. And so I wanted to kind of just back up for a second. This individual, Larry Thompson, who this case is about, apparently the facts are that he and his family were getting ready for bed. Police officers showed up at the house, demanded to come in, and he said, "Hey, you need a warrant to come in my house." And apparently insisted that they get a warrant before coming in his house. I don't see any problem there. But apparently they responded by tackling him. They went in the home anyways. And then they charged him for resisting arrest and obstructing governmental business. And so he was in jail for 2 days. Arick, I know you're probably cringing at that because I'm sure that's what you advise clients to do, right? When police come and say, get a warrant, didn't he do the right thing?
Absolutely. And it is extremely frustrating. And as a civil rights attorney and someone who fights for the rights of minorities who are wrongfully arrested or police brutality type cases all the time, you see this. And that's why I quoted earlier on this resisting arrest. So often we see that as sort of the fallback for police officers who are doing unlawful things, who are arresting people unlawfully, who are violating their civil rights. And then when they resist the unlawful arrest, they say, "Oh, you're resisting, stop resisting." And then they arrest them for resisting arrest. It's really a pretty terrible, unfortunate aspect of the criminal justice system that we see. And it happens all the time. As you know, you're right. The Supreme Court doesn't really get too much into the facts, but the facts here are extremely frustrating and disturbing that this person, and ultimately the case was dismissed, right? The police did not arrest him lawfully because the case was dismissed by the prosecutor. So you're absolutely right. It's something we see far too often, and it's a system, it's just a systemic issue that needs to be changed.
Definitely. Arick, this has been really great picking your brain about this. You're going to be staying with us throughout the program. Also want to make mention that the first oral arguments we brought you this morning, Cameron versus EMW Women's Surgical Center, that is something that we may see a press conference held on this afternoon by Kentucky Attorney General Daniel Cameron. So we're expecting that should be happening at some point, maybe in this next hour. We're going to bring it to you live when it does. So that is that for our Supreme Court coverage for now. In our next hour, we're going to take you live to Brunswick, Georgia for the very latest on motions being disposed of ahead of the start of the trial over the killing of Ahmaud Arbery. Don't go anywhere. This is CourtTV Live, your front row seat to justice. Good Tuesday afternoon to you. Welcome to Court TV Live. I'm your midday host, Julie Grant. We have been listening to oral arguments live before the United States Supreme Court. First, Cameron versus the EMW Women's Surgical Center, and then Thompson versus Clark that just wrapped up. Now, the Cameron listed in the first argument is Kentucky Attorney General Daniel Cameron. At issue in this case is whether the Kentucky AG can defend an abortion law. Now, Cameron is expected to hold a press conference at any moment. We will bring you that live as soon as it begins, so we're watching that carefully. And then on tomorrow's docket, the High Court will be hearing 2 more arguments. You can hear them right here on Court TV tomorrow morning at 10 a.m. Eastern Time, so tune in for that. We begin this hour with our next big trial. Court TV will be bringing you gavel to gavel. We will be heading to Brunswick, Georgia for the trial for Gregory and Travis McMichael and William Roddy Bryant. They are accused of murdering Ahmaud Arbery. Jury selection set to begin on Monday, and you can get updates from the case right here on Court TV Live. Now, the judge has ruled on a pretrial motion that could have a very big impact on this trial. Jailhouse phone calls made by the defendants will be allowed to come in at trial. Court TV anchor Ted Rowlands has more on those calls.
I have been filleted and laid out as a sacrificial lamb. It's all political.
That is Greg McMichael talking to his brother on a recorded jailhouse call.
This narrative that we just shot a black kid for running through a white neighborhood is absolutely.
Defense attorneys want all of Greg and Travis McMichael's jailhouse conversations with family and friends excluded from trial, saying it would violate their due process rights.
You've heard the old saying, no good deed goes unpunished?
Yeah.
Well,
yeah, that's it. That's a shining example right there.
Yeah, that's right.
The defense says prosecutors will argue the good deed Greg McMichael had in mind was the killing of Ahmaud Arbery. But in a motion, they contend what Greg actually had in mind was the, quote, attempt to conduct a private person's arrest of Arbery, so police could investigate whether Arbery was responsible for a string of neighborhood burglaries. In a later call to his wife, Greg McMichael gets angry discussing his daughter's social media post, which showed a photo of Ahmaud Arbery's dead body.
She has got to stop.
She will.
And get rid of that stuff.
Yeah.
Make it disappear. Make it go away. Because people
yeah.
are accessing it. If not, it's liable to really screw us up.
That phone call was brought up by the prosecution at the McMichael's bond hearing.
We had talked about the social media post by your daughter, Lindsay. That post was actually made with a picture of the crime scene while she was under your roof. Is that accurate?
That's accurate.
Okay. This becomes significant because of some of the cross-examination of Lee McMichael regarding jail calls that are captured regarding Greg McMichael actively attempting to obstruct the investigation of this case.
Many of the phone calls that Travis McMichael makes in jail are to his friend Zach, who also testified on the McMichael's behalf during the bond hearing.
Are y'all close? You and Travis?
Yes, sir. Oh, yeah.
Okay. How close would you say that you are?
He's my best friend.
On the phone, Travis tells his friend what matters most to him.
So I'm just praying that I get a bond, where I can get out of here and raise my boy and really be able to put it nose to the grindstone.
Travis and his mother talk about how big the case has become and what lies ahead.
This is going to be a trial with the TV station, with OJ, like an O.J. Simpson trial.
Oh my God!
But that's a good thing because they're going to see facts that's not there that they haven't seen.
What it boils down to is 12 people going to decide what's what.
Right. Well, exactly.
It'll be a long process, though.
That was Court TV anchor Ted Rowlands reporting there. Now let's bring in Court TV legal correspondent Julia Janae. She's live in Brunswick, Georgia this week for us, bringing us the very latest day in and day out with all these developments coming from the court ahead of trial in the Arbery case. Julia, good afternoon to you. Break down for us, please, the court's ruling on these jail phone calls that can now be used against these defendants at trial.
Good afternoon, Julie. This judge saying that their motion to exclude is denied. This defense wanted really a sweeping ruling from the court, saying that none of the jail calls could be allowed to come in, and they used 4 different types of arguments. They said that there was a violation of an expectation of privacy under the 4th Amendment, that there was a violation of their client's right to due process, that there was spousal privilege that attached to the communication between Gregory McMichael and Lee McMichael, husband and wife, and that there was no way for them to know, or that it should not be used to punish them, that it violated equal protection. So here's a look at what the judge had to say about that 4th Amendment argument. Said that the defendants received repeated warnings that the calls were going to be monitored and recorded, and that they have a logically lowered expectation of privacy in prison, and the defendants consented to the detention center's policy by using the phone system. Accordingly, there's no reason to think that the phone calls could not be used at trial, just like any other lawfully discovered evidence. And then here's what the judge had to say on spousal privilege. He said that his decision, this is talking about Gregory McMichael and speaking to his wife, that his decision to proceed with those conversations, despite the notification that those conversations were being recorded, were subject to monitoring, and it's no different from the defendant electing to proceed with those conversations, notwithstanding the known presence of a third party within earshot of a conversation with his wife. This judge pointing out that spousal privilege applies when it's a confidential conversation and when the parties attempt to make it confidential, saying that there's no way they could have believed that this was a confidential conversation on a jail call.
Right. Excellent ruling by the court. We had discussed that one before. We thought the court would probably go that way, and His Honor did. Julia, tell me, with respect to those calls, I know that there are several of them. Is there any indication by the prosecution team of which ones they really might be wanting to hone in on for the jury at trial?
I mean, an important thing to point out about this ruling is it's not saying that all the jail calls can come in per se. It's really saying that the defense can't block them just based on those 4 points that I mentioned. But the judge mentioned during the pretrial hearing that there can always be an argument if there are any other problems with the jail calls, if the information is not relevant to the case, or if it's highly prejudicial and that outweighs the probative value in an inflammatory way. So there were other rules of evidence that he said they could make arguments on, but he had a concern that there was not a selection yet from the prosecution. Here's a bit from that hearing.
The motion was filed on behalf of the McMichael defendants with a response from the state. Let me tell you how I generally handle jail calls and see whether or not that short circuits this proceeding today. In a lot of cases, we get jail calls. The problem with jail calls, and maybe we're at a bit of an advantage in this case, is a lot of times those jail calls are dumped in discovery just before trial. And they're a large quantity of calls and have to be listened to. I'm not sure whether or not the quantity of jail calls and the length of jail calls is one. This is one of these cases where it's burdensome and a problem. I say all that because usually this is resolved by some discussion between the state and the defense over specifically what jail calls are going to be used, so that we can narrow that down and not waste anybody's time reviewing evidence that's not going to be tendered anyway. That also then leads, sometimes leads to objections specifically to what may be in the jail calls themselves. I'm willing to your argument over the admissibility of the jail call, whether or not the system used is an appropriate system. That seems to be a good use of the court's time today, but I want to hear from the parties whether or not this is one of these matters that if in fact these jail calls are going to come in, they can be narrowed down so that we have a concrete set of evidence that we're dealing with.
So we don't have yet anything on the record as far as which ones the prosecutors want to use. We know during the bond hearing, they brought up the ones that they believe showed that the defendants were trying to obstruct justice, or particularly Gregory McMichael, in the communication that they used, or that he was saying to different people, including his wife. But that one about calling possibly the killing of Ahmaud Arbery a good deed, I could see that possibly coming in before this jury and used by the prosecution to show motivations that day.
Julia, thank you kindly for that update. We'll check in with you a little later in the show. I understand that press conference is kicking off with the Kentucky Attorney General Daniel Cameron. Let's listen.
Answer any questions that you might have.
All right, we'll start with the Associated Press.
Yeah, hi, General. It's Bruce Schreiner at the AP. I guess, first of all, do you think that there are other cases? Obviously, the other big case that's before the Supreme Court now. Do you think that or other cases could eventually make this case even moot? Because, I mean, even if you get a chance to take it before the Sixth Circuit again, that could be time consuming, correct? And then also maybe even to take it before the full U.S. Supreme Court.
Oh, well, Bruce, we were obviously honored to be here. House Bill 454 bans life dismemberment abortions. I think, as expressed in 2018 in a bipartisan fashion, that bill, that law conveys and expresses the heart and compassion of Kentuckians. Say if this procedure, the dilation and evacuation procedure, is to occur, and not necessarily that we want it to occur, but if it occurs, we don't want that baby to feel pain. So I think it's still appropriate that we continue our advocacy and defense of it. Again, I don't want to put the cart before the horse. Bruce, you know that we've got to get a ruling from the Supreme Court first before we're given a second bite at the apple, if you will, and have a rehearing on this law. So I don't know exactly what the Supreme Court's going to do as it relates to those other cases that you've alluded to, but I'm hopeful and optimistic that we will have a chance to continue to defend House Bill 454 in the Sixth Circuit Court of Appeals.
Thank you, Bruce. Next, we have the Courier-Journal. Is the Courier-Journal?
I hear it took a second to unmute. This was a fairly narrow procedural issue that was argued today. Do you think the public can really grasp what's going on here and what the significance would be if you were to prevail?
Is this Ms. Yetter?
Yes, sir. I'm sorry.
Hi, Debbie. How are you? I think that the public has been able to understand what we're doing here. As I've said from the very beginning, this is about our ability to continue defending House Bill 454 in the Sixth Circuit Court of Appeals. At the base level, what this case is about is state sovereignty and the ability of this office, as contemplated by the General Assembly, to be a fail-safe, meaning that if any other office, whether it be the governor's office or a cabinet or department, decides not to defend law, that this office stands as the fail-safe to continue to exhaust all appeals.
Thank you, Debbie. Next, we have Courthouse News.
Hi, this is Kelsey Reichman from Courthouse News. I was just wondering, part of your argument is that in light of June Medical, the decision would be different. Can you kind of explain the connection between the two cases, like your law and June Medical, and how June Medical would change things?
Well, I'll let Matt Kuhn speak more specifically in detail, but from my judgment, from my perspective, what June Medical did was get rid of, in many ways, what had normally been considered out of a women's whole health case as a balancing test to look at and determine these pro-life measures. What the Supreme Court said in so many words is that perhaps it's not necessary to use that balancing test, and instead we can look at fact specifics to a particular law. Here for us would be House Bill 454. So we think that because of that analysis changing, it could have some bearing on House Bill 454 when, again, if we prevail here at the Supreme Court, get our chance knocking on the door of the Sixth Circuit to go back there, get that second bite at the apple, we'll be able to articulate that new standard that was set out in June Medical.
Thank you, Kelsey. Next, we have Kentucky Fried Politics. Nick Storm.
Hey, Nick.
Nick, are you on the line? Okay, we'll come back to them. Next is Kentucky Today. Tessa Redmond.
Tessa.
Hi, General Cameron. My question is, you've said that this case is mostly in relation to state sovereignty, but it does relate to a pro-life bill or abortion ban. And I've seen a lot in the media that this is being reported on as banning the D&E abortion procedure outright. And it's my understanding that House Bill 454 is in relation to live dismemberment abortion and aborting a living fetus. Could you just clarify that issue for us?
Tessa, that's exactly right. This does not ban all live dismemberment abortion. What it does is ban live dismemberment abortion. In Kentucky, what we have said, what we've articulated from our legislature that represents the people here in the Commonwealth, again, in a bipartisan fashion in 2018, made it very clear with one voice that we are going to respect life and show compassion, meaning that we don't want a baby in the womb, if this dilation and evacuation procedures to occur, to feel pain. I think that is an appropriate, responsible thing for Kentucky to do. I'm hopeful that if we win here, we will have the opportunity to go back into the Sixth Circuit Court of Appeals and continue defending this case.
Thank you.
Thank you. Next, we have KET. Is Shelby with us from KET? Okay, we'll come back. McClatchy. Spectrum News, Joe Ragusa.
Howdy. So I want to ask just kind of a broader question about what is the overall point of this kind of legal challenge. I know it's been kind of decided at the lower court level, and we've seen kind of how the courts have ruled over the last few decades in regards to abortion restrictions. I mean, are you anticipating a change in the court's opinion on abortion in light of kind of the makeup of the court in the future? Or, you know, why are you trying to keep this challenge alive, or rather this, why are you trying to keep this legal challenge alive?
Well, as an initial matter, I think what we've tried to articulate in front of the United States.
All right. I am being told we're going to take a break now. We'll get you back into that press conference after this. Welcome back to Court TV Live. I'm Julie Grant. We were just bringing you that press conference being held by Kentucky's Attorney General Daniel Cameron. And he is part of this case that was just argued this morning before the United States Supreme Court. And essentially, he just told everyone that this is about state sovereignty, about wanting to be able to defend the laws of his state, and that the Attorney General's office should be a quote-unquote fail-safe to defend laws when they're enacted, in particular House Bill 454 there, which would block a second trimester abortion procedure. So let's go back in exactly where we left off. We cut off his answer there. You're going to hear it from the start now. Let's take a look.
As an initial matter, I think what we've tried to articulate in front of the United States Supreme Court, Joe, is the fact that in Kentucky, our legislature has said that this office functions as a fail-safe, meaning, again, that at a default, this office, the AG's office, should have the ability to exhaust all appeals related to a law, notwithstanding whether it's a pro-life measure or any other law, but this office should have the ability to exhaust all appeals on that law. As it relates to House Bill 454, again, if we win here, as I noted earlier, the June medical decision kind of changed what had traditionally been known as the whole women's health balancing testing. We've gone away from that based on what the Supreme Court said in June medical to a more fact-specific analysis. Again, I'm hopeful that if we get an opportunity to have this rehearing, that the lower court, the Sixth Circuit Court of Appeals, will include that in part of help or allow that to inform their analysis going forward.
Thank you, Joe. Next, we have Washington Times. Christy with Wave 3. WDRB.
Yes, General Cameron. Hi. It's always hard to tell by the questions the justices asked, but give me your sense of how they were receiving your arguments this morning.
Well, I'll let Matt speak on this more specifically, but I thought they were very receptive. They asked very informed and enlightened questions, as you would expect the justices to do. So very honored to have them consider this case. As you know, Lawrence, for the court to take the writ on this case itself was a big step in terms of their willingness to strongly consider what we're asking for the ability to continue defense of this measure. So again, I'll let Matt speak more specifically, but I thought the reception was very, very good as it relates to our position and the advocacy of our Deputy Solicitor General, Matt Boone.
Thank you. Next, we have WHAS Radio, Paul Miles.
Thank you, General Cameron. This is sort of along the same lines as what Lawrence was asking. Justice Sotomayor seemed to express some reservations about the arguments made by Mr. Kuhn, but at the same time, Justice Breyer posed some pretty tough questions to the ACLU attorney. Based on what you heard, do you feel like any of those questions favored one side or the other? And can you get any feel at all as to what direction the court may be going in this case?
Well, again, Mr. Miles, I don't want to put the cart before the horse. I am grateful for the questions that were asked. I know Matt has that same viewpoint. Obviously, you don't necessarily know how they might ultimately come out on a particular case, but I was, I think, heartened by some of the remarks and some of the comments and I guess questions that were raised by Justice Breyer. But again, they have to go back, and this is just one part of their deliberations. For instance, the briefs that we put forth before the oral argument are very informative and help them arrive at a judgment. This argument today that our deputy put forth and the opposing counsel put forth as well helps inform their decision-making process. And then at some point, they'll go into a room and have additional deliberations and talk out what you saw displayed today in some of the questions that they were asked. They'll continue that analysis. And so what I'm optimistic about is that I think you saw from our Deputy Solicitor General Matt Kuhn, someone who well articulated and represented the values of Kentucky and the responsibility that this office has to defend the laws of the Commonwealth. I know I've said from the get-go, in the run-up to having the opportunity to serve in this office, that was the responsibility of the AG's office to defend the laws that are passed by the General Assembly. That's contemplated in KRS 15020, that we have the responsibility, again, as a fail-safe, to make sure that we're defending the laws and exhausting all avenues related to those laws.
Thank you. Next, we have Christian from WKRC. WKRC. Next, we have WKYT. Next will be LEX 18, Carolina.
Hi, General. Hey, I know we've talked about this before, but this case is a more technical argument, but indirectly, it does have to do with abortion. Personally and professionally, why is it so important for you to try to defend this pro-life law?
Well, Carolina, I'll start with personal. As I've shared with you, my wife and I are expecting a baby boy in January. And so it makes it on a personal level more real for me and for her and for what we're doing in this office in terms of standing up for life in the womb. I'm always going to stand up for life in the womb. And I think, again, getting ready and expecting and preparing for a child certainly made that more personal for me. And then on the professional side, as I just mentioned to Mr. Miles, it's important for the AG's office to be that fail-safe, to make sure that we are defending the laws of the Commonwealth without fear or favor. I wholeheartedly agree and expect that should be the responsibility of the AG's office, and you all should expect that as well. And so on a professional level, it's a responsible and appropriate thing to do for us to continue to defend the laws that are passed by our General Assembly. It's contemplated by KRS 15020, but we have the responsibility to do so when all other departments or even the governor's office decide not to.
We're going to take a break since we are at the bottom of the hour. When we come back, we'll get you right back in on this press conference where we left off. Thank you for watching Court TV Live. Thanks for staying with us here on Court TV Live. Let's go back into that press conference. It's being held via Zoom with Kentucky Attorney General Daniel Cameron.
Hi, General. Shaquille Lord with WLKY News. The ACLU says you missed the 30-day window to appeal. If things go in your favor, do you feel down the road this is setting a precedent that when these type of situations come about, that even though it's outside of that window, it sets a precedent?
No, I think what we have is, as was noted during the case, is that we have preserved the right to intervene. And so that is what we've done, and there's been no prejudice or no delay. We did so 2 days after it was noted by the Secretary for CHFS that he would not continue this defense. As was noted during the argument, somebody's got to pick up and defend the laws of a state, and state sovereignty requires that there be someone who stands up and defends the laws that are passed by our General Assembly, that defends the laws that reflect the values of Kentuckians. And again, I think it's important that that responsibility, again, is contemplated in KRS 15020, falls to this office to do and be that fail-safe.
Next, we have WUKY.
Thank you, General Cameron. I'm Karen Czar with WUKY. What would you say to those Kentuckians who worry that House Bill 454, in particular reproductive rights advocates, who worry that this is just one step to completely banning all abortions? Thank you.
Well, I'd say that in 2018, when this law passed, it passed with bipartisan support, meaning Republicans and Democrats. Again, I think it expresses the values and the compassion of Kentucky to say that if this procedure is to occur, we do not want that child to feel pain in the womb. The dilation and evacuation procedure is gruesome. It rips a baby apart. We don't want a child to feel that pain. And I think on a compassion level, on a humanity level, that is all the Commonwealth said. And they've said it loudly back in 2018 and ultimately want to see this law go into effect. I'm optimistic that, again, if we win here, we'll continue the defense of House Bill 454.
Thank you. WCPO. Newsy. Epic Times.
Hi there, General. How are you?
Hi, how are you?
Great. I know it has no precedential value, but the fact that the Supreme Court refused to get involved with, refused to block the recent Texas abortion law, does that give you any kind of optimism in terms of the prospects of your case?
Well, that was more of a question different from what we put forth to the Supreme Court in terms of, again, our representational capacity or ability to intervene, to defend the laws of Kentucky. So that, I think, case or their refusal to hear, if you will, the Texas law is a little bit, has a little bit of a distinction between what we've presented to the Supreme Court in terms of state sovereignty, our ability to continue defense of House Bill 454.
Thanks.
Yes, sir.
Thank you. Is there anyone that has a question for Attorney General Cameron that we've missed? Okay, thank you all.
And if I may, I'd like to allow Matt an opportunity if you think there's something else that might need to be said to the folks. But in addition, the part about the interactions of the justices, I don't know if you have anything on that front. Okay, he's good to go.
All right. Are there any final questions? Okay. Thank you all very much.
Thank you all for covering this very much.
All right, so there we have it, that press conference taking place via Zoom with Kentucky Attorney General Daniel Cameron. And if you're just now joining our coverage, we thank you for that. Just to kind of give you the quick facts on this, he has joined in this action to intervene. Essentially, this boils down to the Kentucky Attorney General wanting to intervene, wanting to defend a state law. This law in particular that this case is about, House Bill 454, blocking a certain abortion procedure in the second trimester. He said the reason for that, the policy behind the law, was to respect life, show compassion, and to not have the baby at that point feeling any pain. And so he wants to intervene, and there's a question of whether he can do that, presented before the high court. And so you heard him taking questions from reporters from all of sorts of different places, and we will see how this case winds up shaking out. But I want to get our reaction from our guests on the program today. We have with us civil rights attorney and former prosecutor Arick Fudali, and just joining us, criminal defense attorney and former prosecutor Arick Fudali. Great to have you both. And I'm going to have to use your last names, I see, in order to differentiate, so we're not all talking at once, right? So Arick Fudali, I'll start with you since you're just joining us this hour. Tell us what you think is important to take away from this. You know, oral arguments, we know they can be hard to understand. It's all really heavily focused on intricacies in the law, procedural issues. It's not like what we're used to talking about here on CourtTV, the trials, the facts, the stories. What are the big takeaways for you on this one, please?
Yeah, Julie, I think there are two things. One is that the coverage has been pretty nice to Kentucky Attorney General Daniel Cameron here. What essentially happened was there was this Kentucky abortion law, and some abortion providers sued saying it violated the Constitution. And a district court agreed after a trial, and a federal appeals court agreed. And then Attorney General Cameron missed his appeal deadline. He screwed up. He messed it up. He was not able to lodge his appeal within the 30-day time frame. And so now he's coming to the court kind of hat in hand and saying, hey, I messed up, but I still want to be heard on this case. Will you let me do that? And so that's one of the issues before the court. I think one thing to at least be mindful of is some perspective here, right? So this is a procedural issue in front of the court. It's a technical issue, whether the Attorney General can intervene under these circumstances. But let's look at the bigger picture, which is what one of those reporters brought up. And the bigger picture is the composition of the Supreme Court is substantially different than it was 5 to 10 years ago. And it's probably more favorable to this Kentucky law. And so, what are the motivations behind the Attorney General of Kentucky trying to intervene here? Is it strictly this procedural technical issue, or is there something more at play? And does he think he can sort of move the dial a little bit on the abortion issue to his favored position?
Understood. Arick Fudali, same question to you. What's jumping out at you, please, as you've listened to those arguments today and then heard what the Attorney General there in Kentucky had to say?
Well, I agree with a lot of what Arick said, but I would add that really what this is it an attempt by the Attorney General in Kentucky to chip away at a woman's right to choose? That's what this is. And what I thought was interesting is he was given the opportunity a couple times to connect this case to, of course, the Texas abortion rule that the Supreme Court declined to hear. And he kept distancing himself away from that. He said, oh, no, this is a different issue. This is a different issue. And I think that is pretty revealing as to, what that Texas abortion law did, and that even this Kentucky Attorney General is not taking the bait to say, well, yes, hopefully the Texas law will withstand any Supreme Court scrutiny, then ultimately this Kentucky law will. So he attempted to distance himself from that. But really it is just an attempt to chip away at a woman's right to choose through, and like Arick said, they already had their chance to do that. He missed the deadline. This is not, as he said, a fail-safe, a chance for the Attorney General to come in and defend. No, it's a chance and a Hail Mary to re-defend a lawsuit that was already ruled unconstitutional twice.
Arick Fudali, Arick Fudali, thank you both for weighing in on that. We have lots more we want to discuss in this program. Again, tomorrow we're going to be bringing you more oral arguments from the U.S. Supreme Court, different cases being heard. Of course, 10 a.m. Eastern time, it will all begin. Stay right there, because also this afternoon we are waiting to hear a press conference releasing the findings of the autopsy done on Gabby Petito. We know the search for Brian Laundrie is still on at this hour, so we're going to be speaking about that case and what, if anything, we may learn this afternoon and how that could change the search in any way for Brian Laundrie. This is Court TV Live, your front row seat to justice. Welcome back to Court TV Live. I'm Julie Grant. We're following for you some new developments in the Gabby Petito case. A Wyoming medical examiner will be holding a press conference a little later on this afternoon regarding the autopsy findings. About a month ago, 22-year-old Petito was reported missing by her family after her boyfriend, Brian Laundrie, returned home to Northport, Florida from their cross-country road trip without her. Now, a week after she was reported missing, Petito's remains were discovered at the edge of Grand Teton National Park in Wyoming. The search is still on today for Gabby Petito's 23-year-old boyfriend, Brian Laundrie. We know that there is a federal arrest warrant out for him on access device fraud charges. So not on homicide charges, but access device fraud charges. He is still a person of interest, the biggest person of interest in her disappearance. Now, those results are expected to be discussed, the autopsy results, that is, at a press conference this afternoon, 2:30 p.m. Eastern Time is what we are told for the start time. So as soon as that begins, we're going to bring you that live. Now, on August the 12th, so about a month before she was reported missing, Moab, Utah police officers responded after a van that Brian Laundrie was driving hit a curb. And in the body camera footage, you will see a very emotionally distraught Gabby Petito telling officers how she was to blame for the incident as their argument got physical. Take a look.
My name's Arick. I'm with Moab Police. What's your name?
Gabby.
Gabby, how old are you?
I'm 22.
What happened? What's going on?
I'm just having a very stressed morning.
Yeah. Is this your husband or boyfriend?
My fiance.
Fiance? Is he a pretty good guy?
Yeah.
What happened over at Moonflower?
Well, I was just really stressed this morning trying to get a lot of work done, and I was apologizing to him. I had thrown a bunch of stuff in the bag, and all our bags are back there. I was just apologizing. I was like, I'm sorry that I get so stressed out because I have OCD and I was just like organizing stuff, and sometimes I just have a mean attitude, but I'm not trying to be mean about straightening things up and stuff. So I was just apologizing, but I guess I said it in like a mean tone, and he got really frustrated with me, and he locked me out of the car and told me to go take a breather, but I didn't want to take a breather because I wanted to get going. We're out of water.
So it kind of made you more upset.
Yeah,
it didn't help calm you, it made you more upset.
Yeah.
So then what happened?
And so our goal was to come here and come refill our water.
Are you guys living out of the van right now? On travels?
Yeah.
Okay.
So it was just really.
So what happened after he locked you out? I told you to take a breather.
Well, he walked away to go take his own breather, but I wanted to sit in the car because all my stuff was in the car. I had to run my bag, and I was working on something at the moment in the car, and he told me to just relax for a second, and I didn't want to relax, so I got really mad. And, I mean, I don't need to be mad.
Yeah, that happens. Then what happened?
And then I told him to drive and get water because I was really thirsty.
Yeah? Is there something on your cheek here? Looks like, did you get hit in the face? Kind of looks like something like hit you in the face. And then over on your arm, shoulder, right here. That's new, huh? It's kind of a new mark.
Oh yeah, I don't know.
Can I see the other side of your face? So, what happened here and here?
I'm not sure. It was really fast. I was just trying to get in the back of the car, and his backpack was on the back, and it got me.
So the backpack got you? So there's two people that came to us and told us that they saw him hit you. There's two people saying that they saw him punch you. We're just independent witnesses by Moonflower.
Well, to be honest, I definitely hit him first.
Where'd you hit him?
I slapped him in the face.
You slapped him first? And then what, just on his face?
Can you get to shut up?
How many times did you slap him?
Romeo, India, Alpha. Just a couple.
And then what? And his reaction was to do what? gonna be out of Florida.
So I wouldn't have him.
He just grabbed you?
Yeah.
Did he hit you though? I mean, it's okay if you're saying you hit him, and then I understand if he hit you, but we want to know the truth if he actually hit you.
I
Because
guess, yeah, but I hit him first.
where did he hit you? Don't worry, just
Well,
be
he
honest.
like grabbed my face, like, I guess. He didn't like hit me in the face, like he didn't like punch me in the face or anything.
Did he slap your face or what?
Well, like he like grabbed me like with his nail, and I guess that's why it looks. I definitely have a cut right here because I can feel it.
Yeah.
When I touch it, it burns. But
Okay. So has he been drinking?
no, we don't drink.
Okay. What was up with his driving? This officer said he hit a curb
I hit him.
while you're driving.
Well, he was driving.
While he was driving, you were hitting him,
Well, not a lot, but yeah.
and that was distracting him while he's driving. Are you
Not
trying?
only for like a second, only because I saw the lights come on, and I like kind of like so stupid.
Did you already tell him all this?
I didn't get that far into
Okay,
it. She
so-
was hyperventilating.
She's
a
saying
little
that
bit.
they don't drink, but at the point when you let them up,
You don't drink or anything.
She started hitting him.
I was yelling at him, and then when you turned your lights on, I like kind of punched her. I'm like, you're just an idiot.
she's saying was why he hit the curb. You said it was Gabby? I'm sorry, I'm really bad. Name was Gabby?
Yeah.
Okay. You okay, Gabby? Do you have medication for anxiety you take or anything? Do you take any medication for any,
I just do yoga and
try to meditate and stuff? But you tend to have a lot of anxiety and stress?
I have a lot of anxiety.
And what's his name?
OCD.
Is it Brian? Is he usually pretty patient with you?
Yeah, but it just makes me upset. I know that he definitely gets frustrated with me a lot because I have a lot of anxiety, and he definitely has anxiety too.
Oh, that could be a
but
bad combo if you both have anxiety. I have anxiety too, and my girlfriend,
we usually work together.
my girlfriend's really, really calm, and she has a way of taking my anxiety and bringing it down. But my ex-wife, that's why she's my ex-wife. I'm just sharing. I know it's a little personal, but to help you understand, we would feed off each other's anxiety and it would spiral. You know what I mean? And it doesn't matter how much I loved her. It may be bad for your soul.
To me, it seems that officer really understands what a toxic relationship is and how that can play into domestic violence relationships. As this one, many have speculated, including myself, based on past experiences as a prosecutor, that this may have been one of those relationships. Let's bring in our guests on the program today for some analysis. Civil rights attorney and former prosecutor Arick Fudali and criminal defense attorney and former prosecutor Arick Fudali. Arick Fudali, let me start with you on this one, please. With respect to this officer, this was a body camera footage that was released a little bit later. The other one had circulated first, and different officers are seen talking to her. And this one really strikes me as assessing the situation well, how he's pointing out her injuries. He's talking about what the witness related to them about seeing a man hitting a woman, how he uses himself as an example of what it's like to be with someone who ups your anxiety. I know that hindsight is 20/20. I know no one is to blame for this. All of those officers have a really tough job, and we can't rewind the clock. But as you were watching this, what was jumping out at you, seeing that officer interacting with her, please?
Well, I agree with your assessment, and I've represented a lot of domestic violence victims in civil suits. And what Gabby is doing, which is so devastating to see, is she's really exhibiting all the signs that you see of domestic violence. She's blaming herself. She's making excuses for it. She's saying, well, I did this, saying, I don't know, when asked specific questions about what Brian might have done. So I agree. The police officer is doing a good job. He's asking the right questions. He's getting the information you seek, but ultimately it doesn't seem like it was ever acted upon. Ultimately, of course, they were allowed to be, reconvene. So it really is devastating to see her exhibit such, from my perspective, such obvious signs that something was really wrong here. And the officer getting her and sympathizing with her, apparently, to get those answers. But then ultimately, of course, the worst possible thing ended up happening.
Right. Yeah, I'm with you. If I had to bet on it, I would bet that was the kind of relationship it was, for the reasons you stated, reasons we've stated before on this program, and we're going to get some more insight within the half hour, really, from the Teton County coroner. Arick Fudali, I know we need to say goodbye to you at this hour. Thank you so much for coming on the program, lending us your insight. And we're going to squeeze in a break right now as we're nearing the top of the hour. When we come back, of course, we're going to dig more into the Gabby Petito case at 2:30 p.m. Eastern Time, that press conference with the announcement of the findings of her autopsy. And then, of course, we're going to take you to Brunswick, Georgia, where Julia Janae is standing by for the latest on the Ahmaud Arbery case. We know starting Monday, that is when trial will begin for the 3 defendants accused of killing him. Stay right here with Court TV Live. Good Tuesday afternoon to you. Welcome to Court TV Live. I'm your midday host, Julie Grant. We begin this hour with our next big trial we're bringing you here on Court TV, and that is the case of defendants Gregory and Travis McMichael and William Roddy Bryan, who are accused over the death of Ahmaud Arbery, the jogger in southern Georgia who was shot to death in February of 2020. These are the 3 defendants, father and son there, and their neighbor. And we know that a flurry of pretrial motions have been filed in this case ahead of the jury selection, which is set to begin on Monday. Monday, October 18th is the day. And we've already got our crew in Brunswick, Georgia, standing by. Let's bring in Court TV legal correspondent Julia Janae to talk more about a major pretrial ruling about the jail phone calls that the state wants to introduce against these guys. Julia, good afternoon.
Good afternoon, Julie. We see jail calls come in during trial, but this was a really major part of the pretrial motions in this case. This defense did not want those jail calls, any of them, to come in before this court. They were already being used during bond hearings. And this judge has now ruled that that motion to exclude the jail calls is denied. And here's a look at some of his reasoning, especially when it comes to the argument that there was a Fourth Amendment protection or violation if these calls were allowed in. The judge said that the defendants received repeated warnings that the calls would be monitored and recorded, and they have a logically lowered expectation of privacy in prison. And the defendants consented to the detention center's policy by using that phone system. Accordingly, there is no reason to think that the phone calls could not be used at trial just like any other lawfully discovered evidence. There were also phone calls between Gregory McMichael and his wife, Lee McMichael, where they talked a little bit about the case. There was even a point where he asked her to tell their daughter to take down certain posts on Facebook, on social media, saying that that would really mess things up if she didn't take them down. So here's what the court said about the argument that there was a spousal privilege for that husband and wife communication. It said Gregory McMichael's decision to proceed with the conversations, despite the notification that the conversations were being recorded and were subject to monitoring, is no different from a defendant electing to proceed with conversations notwithstanding the known presence of a third party within earshot of a conversation with his wife. So the judge saying spousal privilege does not apply to jail calls, something we expected, Julie.
Right, Julia. I know we talked about this on the show many times, and the court certainly made the right ruling here. I mean, on those calls, you hear the notification right at the beginning that this is being recorded, which certainly eliminates that expectation of privacy when you're put on notice. And this is far different than pillow talk in a home between a husband and wife when there's notice that this is being recorded and monitored. So great ruling by the court. When we last talked, Julia, we were discussing a little bit of the state's strategy, what we think they might be wanting to introduce at trial and why in terms of the calls, because I know there are a lot of them. And there could be other objections, as you noted earlier, that the defense might be raising. But if you had to guess, what do you think we might be hearing at trial and why, please?
You know, there's 15 or 1,600 calls that jail officials said during a pretrial hearing exist. And the judge even talked about the fact that typically you go through each of these jail calls and figure out what you want, and then you bring it to the court. But there was this motion where the defense wanted all of them excluded just off jump, and that's something that the judge, of course, is denying. But I would think that of the phone calls that I've heard, one that may be key for the prosecution, especially in terms of Roddy Bryan, there's one where Gregory McMichael is saying that Roddy's an ally. Someone is asking him, who is that guy who shot the video? Who was the guy who was with you? And he assures them in a way that sounds like they were very familiar with him and that he is someone who was very helpful to them, that they can trust him. Or we can expect rather from what we've heard from the attorney for William Roddy Bryan is that he's not connected that closely to the McMichaels, that he was someone who was just being a good Samaritan. They asked him to help him in this chase and he joined in. But I think that could be a jail call that these prosecutors could use to show that there's a closer familiarity and support their idea that these three men were acting in concert together in carrying out this murder.
Oh, yeah, that's a really great point you just made, Julia, especially if we see William Roddy Bryan try to distance himself from the other two at trial. So excellent point you just made where the state may try to link him with that. Now, tell me, I know that the McMichaels defense team again, has been pushing to try to get into this trial some details about Ahmaud Arbery. We talked a lot on Monday about how it may feel to Ahmaud Arbery's family that he is being put on trial, that his character is being attacked. And in this next push, the McMichael defense team, they're looking to get in THC levels in his blood to show that he may have been under the influence of marijuana at the time. And also the fact that he was on probation at the time. They want to get into court his probation status and go back to whatever case might have caused that. Talk to us about how the defense is arguing that this should come in, and where do things stand with the court at this time, Julia?
They are arguing that this is inextricably intertwined with the case itself. They feel that this would help a jury determine who was the primary aggressor, which is an important element in a self-defense case. Was Travis McMichael defending himself, or was Ahmaud Arbery trying to defend himself, being a subject or target of this chase? And this comes after the state put into a motion that they don't want any of those things, the probation status or THC levels, to come in. They say there is no proof that THC levels impaired or impacted any of the behavior that day. And they say it's irrelevant because, again, it's not something that the defendants knew at the time of this incident, but the defense says it is going to be key for helping them to show this jury what was happening that day. They say it's not about character evidence, but instead goes to their theory of the self-defense claim in this case. So the judge still has to rule on it. This came in a way where it's a state motion in limine asking the judge to clarify whether or not those two items fall under the character evidence that he already prohibited in this case. And the defense is saying, no, we think that the clarification should be this part should come in.
Wow. Julia Janae reporting live for us in Brunswick, Georgia. Thank you so much for all of that. Big decisions this trial judge has to make. Let me bring in for some analysis criminal defense attorney and former prosecutor Arick Fudali. He's joining us from Denver, Colorado. Okay, Arick, what do you think? First, let's talk about the blood levels, the THC in the blood. Should that have any place in this trial?
What in the world does that have to do with this killing? I just don't see it here, Julie.
Right.
The fact that there may have been some THC in Ahmaud Arbery's blood, and we don't really have any information as to whether that was active or inactive. We don't have any information as to how it could have been affecting him at the time. But really what the facts have shown thus far, or at least the allegations, is that Ahmaud Arbery was just going for a jog when he is kind of targeted, allegedly, by these defendants. And so, what it seems to me is kind of an attempt by the defense to smear this murder victim in this homicide case by calling into question his character and his personal choices. And I just think that they don't have any relevance either to the allegations or to self-defense, because self-defense is these defendants claiming they had a reasonable fear of imminent bodily harm. Well, they would have no idea as to the THC levels of Ahmaud Arbery when all of this went down. So how could it have affected the defendant's calculation in terms of assessing Ahmaud Arbery as an alleged threat? I just don't see it.
Right. I agree with that, Arick. I think absolutely this is an attempt to just attack his character, and they're trying to find a creative way to do it, to try to make it seem like he was a threat. We know that they're going for a self-defense plea. We know that they've got to put on evidence to that end. But as far as getting in the blood results, I mean, the THC, I think if the judge were to, let's just for the sake of our analysis, let's say the judge were to allow this in, what would they need to do then? Bring in an expert, right?
Oh, sure. Yeah, I think that's what they would have to do. They would have to have an expert who somehow is privy to a blood analysis that may or may not have been conducted after Mr. Arbery passed. And that expert would have to come in and say, hey, here are the levels, and here is how it can affect one's behavior. I haven't seen the defense propose anything like that thus far, and I believe we're starting trial on Monday.
Yeah, no, I'm with you, Arick. I mean, we know we've got the video. We see him jogging on the video. We see him being pursued on the video. This is a real head scratcher. I would be really stunned if the court allowed this jury to hear about the THC in the blood for the reasons you stated. It just seems like there is no exception, for this to come in. And if it does, then I guess we'll see what their expert testimony says in terms of how this might have related to the McMichaels defending themselves. And I think I have time to ask you one more quick question, and that was with respect to the second issue the defense wants to get in, and that is his probation status. Thoughts on that, please, Arick?
Hello again. Like, in what way does that affect the allegations? How does it make it more or less likely that these defendants are guilty? How does it make it more or less likely that these defendants were acting in self-defense when they would have had zero knowledge as to Mr. Arbery's legal status and whether he was on probation? The defendants could not have considered that in their calculus as to the allegedly defensive actions that they were going to take, because they didn't know about it. They had no idea what Mr. Arbery's probation status was. So again, I think another attempt to kind of smear the victim in this upcoming homicide trial.
Exactly, Arick. They had no idea. That's what is so key there. And you know that, when we have a homicide case and the defense is looking to put forth a self-defense plea, an affirmative defense, as we call it in the law. And if the person who says they were defending themselves knew that the other person, the said victim, was overly aggressive, or knew their behavior, knew they had killed someone before, knew they would carry a gun, knew they belonged to a gang, whatever the facts may be, then it might go to their state of mind, right, in doing what they did to defend themselves or defend others. But here, they knew nothing about him, never met him, never knew anything. To your point, never knew anything about the probation. What this has to do with the case, I have no idea. But kudos to the defense team for making every argument they can think of. They've been very creative in trying to zealously represent their clients respectively. So have to hand it to them in that respect. Arick Fudali, thank you for your analysis. I'm being told we've got to squeeze in a break. When we come back, we will talk about how the Florida Supreme Court might be overturning a death penalty conviction. Might be. Nothing certain yet. For this guy, you remember him, convicted murderer Mark Sievers, hired two men to murder his wife, Dr. Teresa Sievers. Well, now he's appealing, and we're going to take a look at the arguments his lawyers are making for why he should not be put to death. Thank you for being with us here on Court TV Live.
We, the jury, unanimously find that Mark Sievers should be sentenced to death. Yes. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Dated this 10th day of December in Lee County, Florida.
I judge people's actions. I don't judge people's souls. That's for somebody else to do. Sir, I'm going to go ahead and adjudicate you guilty on each count. On the first count, first-degree murder, it's the order of the court that you be sentenced to death, sir. And the second count, conspiracy, I'm going to sentence you to 30 years in prison consecutive to count one.
That was a look back at Mark Sievers being sentenced to death after he was convicted of orchestrating the killing of his wife by hiring two men to do it, one of them being his best friends. Holistic doctor from South Florida, Teresa Sievers, there you see her on the right, was found bludgeoned to death on her kitchen floor back in 2015. Now, police initially arrested two men, Curtis Wright and Jimmy Rogers, in connection to her killing. But authorities soon discovered that what they shared with them led them to her husband, Mark Sievers.
In the beach town of Bonita Springs, Florida, on June 28, 2015, a doctor, Teresa Sievers, was just arriving back home from vacation alone. She planned to go back to work to her busy private practice, but she never made it to the office.
She's dead on the floor, and there's a hammer at the side.
The next morning, police discovered her body and a bloody scene in her kitchen. The 46-year-old wife and mother was brutally beaten to death in an ambush attack, all while her husband, Mark Sievers, and their 2 daughters were states away in Connecticut.
This was a very safe neighborhood.
Her horrifying death shook the community to its core. Questions swirled as her family grieved.
It's a very emotional time for everybody. So we just ask, that everybody just keeps everyone in these circumstances right now in their prayers.
With no suspects and few leads, police interviewed those closest to their victim. More investigation revealed Teresa and Mark's marriage of 12 years had many layers. Teresa's obituary describes Mark as her loving husband. Friends and family said the couple had typical arguments, often stemming from their shared work. Mark managed his wife's medical office and was a stay-at-home dad. Teresa, the breadwinner, specialized in anti-aging and holistic care. Her practice was inspired by Eastern medicine. But Mark and Teresa's work relationship wasn't the only thing unconventional. Cell phone records and letters recovered by police detailed Mark and Teresa's open marriage, other sexual partners, and a fantasy Teresa had involving Mark's friend Curtis Wainwright. 11 days after Teresa's brutal murder, a tip from an informant took investigators to Missouri.
I seen like 20 SWAT guys or so, a whole bunch of jackets and flak jackets and a whole lot of rifles.
Their investigation led to a suspect, Jimmy Ray Rogers.
Asked us if we seen anything suspicious to give him a call.
Rogers lived in this mobile home park with his girlfriend Taylor Showmaker. She would tell investigators Rogers made an unexplained trip to Florida.
I asked him what he went down there for, and he said to make money. And then asked him how does he make money, and it was murdering Mark's wife. I said, did you shoot her? And he said, no. And I said, then how'd you kill her? And he made a stupid little chuckle that he does, and then said, we think.
Neighbors pointed to another connection. Rogers was good friends with Curtis Wainwright.
He used to go over to Jim's all the time.
Police arrested and charged Rogers and Wright with Teresa's murder. But for the Lee County Sheriff's Office, the case was not closed. Mark Sievers fell under what Sheriff Mike Scott called an envelope of suspicion. Life insurance policies worth nearly $5 million only added to their theory about the sinister plot. Months passed, and Mark remained a free man, fighting to keep custody of his 2 daughters. Then on February 6, 2016, 7 months after Teresa's death, deputies would make their 3rd and final arrest.
I think a lot of people have been waiting for this day.
Mark Sievers was indicted for first-degree murder for orchestrating the deadly scheme.
Wainwright, Jimmy Rogers, and Mark Sievers are locked up where they belong.
Police allege Mark conspired with Curtis Wainwright as early as April of 2015. Then in June of 2015, Wright solicited Rogers to travel with him from Cadet, Missouri to Bonita Springs, Florida to kill Teresa Sievers.
I never in a million years envisioned beating her to death with a hammer.
Did Mr. Rogers reveal his presence to you?
Yes.
How did he do that?
He appeared to my right and started hitting her also.
Wright took a deal and testified against Rogers in October.
Did Dr. Sievers die as a result of something Mr. Sievers did?
Yeah. He approached me and told me that he needed to have his wife killed.
A jury found Rogers guilty of a lesser charge of second-degree murder. What the jury didn't agree on is whether the state proved there was a conspiracy.
The defendant is guilty of second-degree murder. Conspiracy. Check only 1. The defendant is not guilty.
Now prosecutors look ahead to their case against Mark Sievers, hoping to convince a new jury that the out-of-town husband was a ringleader for murder.
Okay, and we know that ultimately the jury was convinced, as we showed you at the start of this segment, that they found him guilty and sentenced him. He was sentenced by the court to death. Now, last week, the Supreme Court of Florida heard arguments made by Mark Sievers' defense team to try to overturn that death sentence. And they cite conflicting witness testimony. We have some of those arguments. Let's take a look at the crux of what his defense team told the court. The defense team arguing that Curtis Wright's testimony was problematic and that it prejudiced the jury. They argued that Wright was given a plea deal to testify against Mark Sievers, just like you saw the deal he was given to testify against his buddy, Jimmy Ray Rogers, as well. The defense said the state failed to conduct a polygraph test of Curtis Wainwright, knowing his history of lies. In response, the state of Florida, one more thing they argued, they claimed that Wright gave conflicting testimony to the court, arguing Wright's story did not corroborate that Mark Sievers was, in fact, even involved. The defense claims that Wright was unaware of Sievers' marital status before her murder. Now, let's look at what the state claims in response. The state says, we dispute these defense claims, saying that the jurors were informed of Wright's previous misstatements, that the state also says that jurors were informed of Wright's plea deal as well. Of course, he's got a defense team. Of course, they're going to make every effort to try to save his life. But at this juncture, the death penalty, it still stands. That's where this is. We know that the court is going to consider those arguments. They just heard them on Friday. So all of this is very fresh. The court will be publishing a ruling in this case, we expect within about 3 weeks. So we'll see what the court does. We will let you know. In the meantime, let me bring in criminal defense attorney and former prosecutor Arick Fudali to talk a little bit about this one. Arick, can you see, as I'm listening to those defense arguments and our research team extracted the most pertinent ones here, I'm not really seeing where they're hanging their hat. Are you? I'm not really sure what the problem was. What was so unfair that this conviction needs to be overturned?
Yeah, Julie, in a death penalty case, as you know, from a defense perspective, you have to scour the earth for any possible angle you can take, especially after your client has been convicted and sentenced to death. You have to conduct investigations, you have to do interviews, you have to look for any piece of evidence or any legal theory that you can propound in order to try and reverse that death sentence. And I think that's what Mark Sievers' defense team is doing here. However, like you said, it seems like it's kind of falling flat. I don't know if this is like an insufficiency of the evidence type of appeal, but a lot of these arguments the defense team should have made to the jury, and perhaps they did. But they should have told the jury, hey, this guy Curtis Wright, you can't believe him. He's got all these prior inconsistencies. He's not a person in whom you should place faith. And the jury disagreed, and they convicted Mark Sievers anyway. So I think for defense to kind of rehash some of those things on appeal, I think it's really gonna fall on deaf ears there at the appellate level.
Yeah, I'm with you there, Arick. I don't know. We watched this trial really closely. We saw the evidence coming in, and hey, criminals roll on one another. That's what happens every day, right, in America, in criminal courthouses all across the country. And here, this Curtis Wainwright got the deal, to squawk and to be the one to help put away these other two. And investigators ultimately determined Mark Sievers was the ringleader, and they pursued the case as such, with Curtis Wainwright getting the deal, and now Mark Sievers getting the death penalty. So we'll see what the court does. Thank you so much for weighing in on that, Arick. We're going to squeeze in a break because in just a couple of minutes, we understand that the coroner in Teton County, Wyoming, is set to have a press conference releasing the autopsy findings in Gabby Petito's death. We'll be right back. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. Right now we are standing by waiting for a press conference to begin in Wyoming. It's going to be held, we understand, by medical examiner Dr. Brent Blue. He is the one who performed the autopsy on Gabby Petito. Now we know it was about 1 month ago that the 22-year-old was reported missing by her family. So that was on September the 11th. We know her boyfriend, Brian Laundrie, returned home to Northport, Florida without her. He came home on the 1st of September. We just showed that body camera footage in our last hour. It's so heartbreaking watching her cry and being so upset as the police are talking with her when they saw the van jump a curb and jerk, and witnesses called in. One of them said they saw him hitting her. Let's go in now live and see what the coroner says.
With assistance from the FBI, the Teton County Coroner Office is filing the following verdict in the death of Gabrielle Lenora Petito. We hereby find the cause and manner of death to be the cause, death by strangulation, and manner is homicide. By Wyoming state statute, no other information will be released about the autopsy. The only thing that is released in the state of Wyoming is cause and manner of death.
I think they said they can't hear you. Just 1 second. Go ahead.
Should I start over then?
Sure.
Thank you for joining us. Sorry about the audio issue. I'm Dr. Brent Blue, Teton County, Wyoming coroner. After a detailed investigation by our forensic pathologist, our anthropologist, and local law enforcement, with assistance from the FBI, the Teton County Coroner's Office is following the following verdict. In the manner of death of Gabrielle Lenora Petito, we find the cause and manner to be cause, death by strangulation, and manner is homicide. By Wyoming state statute, only the cause and manner of death are released. Their autopsy findings and photographs and that sort of material is not released by state statute. And I'll be glad to entertain some questions at this time.
Hi, Brian. This is Alex with the News and Guide. Can you hear me?
Yes.
I'm curious whether you're able to pinpoint a date of death and when, and if you know whether or when Gabby's remains will be returned to her family.
The remains have been returned to the mortuary here, and the mortuary is dealing with the family at this time as far as the disposition of the remains. As far as the time of death, we are estimating 3 to 4 weeks from the time that the body was found. That is actually determined more by the law enforcement folks than than our office.
Chris Vivian, you are able to ask your question.
What's the question? I didn't hear a question.
Chris, I believe that you are muted. If you can unmute yourself.
Okay, it's John Walsh from In Pursuit with John Walsh on Discovery ID. Dr. Blue, thank you for your time. I think everybody in the world believes that Brian Laundrie killed Gabby. With your extensive work on the body, are you sure that it's Brian Laundrie? And will the FBI issue a nationwide homicide warrant now that they know the cause of death?
We are only tasked with the determination of cause and manner of death. Who committed the homicide is up to law enforcement, and I cannot answer the question about the FBI. You would have to contact them.
Jeremy Kopis, you are now allowed to ask your question.
Yes, hello, doctor. If you could please Can you comment on any other bruising, maybe on the body that possibly was healing, possibly older bruises or cuts that might have been healing over the last couple of weeks before her passing?
By Wyoming state statute, no other information about the autopsy is released, just the cause of death.
Hi there, this is Heather Lee, a reporter at ABC Action News in Tampa, Florida. I just wanted to know if you could explain why it took about a month for this process to finish. I think a lot of people were hoping that they would learn this information sooner. So I just think if you could just explain the process and why it took a month.
Well, the main reason was that we were very exacting in our examination and the detail by which that examination was done. We were waiting for various specialists to come in and help us with this investigation. We were waiting on toxicology to be returned, and it was just a matter of making sure we had everything right.
Thank you.
Is there another question?
Brian Enton. I believe you're unmuted right now. Okay. Steve Fabian.
Yes, hi, doctor. How are you? I am curious if any DNA samples were taken from Gabby's remains, and also if the body was intact, are you able to tell us the condition of Gabby's remains?
I can tell you the DNA samples were taken by law enforcement, and all I can tell you about remains is that the body was outside for 3 to 4 weeks.
Chris Vivian, do you have your hand up?
Was that a question? I didn't hear the question there. Question.
Dr. Blue?
Yes.
It's John Walsh again from In Pursuit with John Walsh. You will probably be the most important witness at the trial. And I asked you before how confident you feel that Brian Laundrie, and they use the semantics. He was a person of interest. I'm old school. He was the only suspect ever. And I just wonder, you're going to be the most important guy at the trial, probably. Do you have any doubts it's Brian Laundrie?
I can't make any comment about any suspects because we are not involved in that part of the investigation. We are only involved in the investigation of the body of the deceased. So who committed the homicide is really to be determined by law enforcement.
Right, but I thank you for your hard work. And I always say in so many cases I've been involved in, let the pathologist and the coroner do their work no matter how long it takes. So I think you've probably done a really good job on this case. Thank you for your time.
Hey there, doctor. This is Rochelle Aline with ABC Action News in Tampa. Just a quick question. Can you kind of walk us through the process to how you arrived at this specific manner of death?
In the state of Wyoming, there are 4 possibilities for the manner of death. They are homicide, suicide, accident, and natural. And those are the 4 choices. When we do an investigation, we look at the crime scene or the scene of the death, the scene of the body, the condition of the body, and findings at autopsy and toxicology. And that is how we arrive at the manner of death. So it really depends on lots of different circumstances.
Dr. Stephen Fabian again from Inside Edition. Can you tell us if the body was buried when it was discovered, or if the body was on the surface?
I can't tell you that. That's would be something you'd have to ask the FBI, because we're not allowed to release that information.
Kelly Vaughn. Do you have a question, Kelly Vaughn? We have Brian Enting in the chat who has a question. What's your question, Brian? Was there any impact on her body from weather or wild animals in the national park?
I'm sorry, I didn't hear the question.
Was there any impact on her body from weather or wild animals in the national park?
All I can really comment about that is that her body was outside in the wilderness for 3 to 4 weeks.
KSL assignment, you are unmuted. KSL assignment.
Hello, Dan Rascone here from KSL TV in Salt Lake. Dr. Blue, can you tell us at all whether or not, was it believed that she was murdered there at that location, or is it any indication that her body was drugged there or taken there, or can you give us any indication there?
I can't comment on that. That would be something you'd have to speak with the law enforcement or the FBI.
Matthew Sella. Matthew Sella, do you have a question?
Hey, Dr. Blue. It's actually Jimmy from dailymail.com in New York here. What were the results of the toxicology report? And is there any suggestion that Gabby had any drugs in her system? And if so, what were they?
The results of the toxicology are not public knowledge by Wyoming statute, so I can't comment about that.
Thank you.
We have a question from the chat. Was Gabby Petito pregnant?
She was not pregnant.
Thomas Taupe.
Hi, doctor. My question, did you seek the advice of a forensic entomologist or forensic botanist during the course of your investigation?
The FBI has sent materials to a forensic entomologist.
WPBF 25 News.
Hi, doctor. This is Terry Parker from WPBF in Palm Beach County, Florida. I'm wondering, if you said you were very thorough in this autopsy and examination, could you give us an example of the type of test and analysis you performed?
This autopsy included a whole body CAT scan, a examination by a forensic pathologist, an examination by a forensic anthropologist, and toxicology evaluation. So we pretty much covered all the bases.
Jeremy Kopis.
Yes, doctor, thank you for taking the question again. You mentioned that strangulation is the cause of death. Can you talk about how you came to that conclusion?
I cannot. That is part of the autopsy findings and is not discoverable by Wyoming statute.
Was there any other cause of death that was a possibility in this case?
Well, we look at all causes, all possibilities when we try to determine cause of death, but this is the cause of death that we determined.
I have a question from chat. It is, was the manner of death obvious? Strangulation marks, bones, injured neck.
Nothing is obvious in a situation like this. So detailed analysis was used both to determine manner and cause of death. I can't go into details on how we made those decisions.
Kristen Thorne.
Yes, hi, Dr. Kristen Thorne with WABC in New York. Could you just please repeat about how long you believe the body was out there? Unfortunately, the last time you spoke, we just didn't get a good film shot of you saying that. Would you mind repeating that?
Our initial determination is the body was in the wilderness for 3 to 4 weeks.
Thank you.
Jorge Fitzgibbon. You have to unmute. I believe you're still muted.
Sorry about that. Good afternoon, Dr. Blue. Relating back to the date of death, is there a date listed on the death certificate?
The death certificate has not been completed at this time, and the death certificates of the state of Wyoming allow for approximate dates and variability in those dates. So I doubt, well, there will not be an exact date of death on the death certificate.
Eileen with News 12.
Hi, doctor. This is Eileen LaPalmer from News 12. We sort of asked it a little bit, but is there a way that you can explain how you know that it was strangulation? Sometimes I know that a hyoid bone could be missing. Is that something that you discovered in this case?
I can't comment on that because it would be a finding of the autopsy. And as I stated before, in the state of Wyoming, the autopsy results are not public knowledge.
So then you can't clarify whether it was manual strangulation or with an item, correct?
That's correct.
Michael Ruiz.
Thanks for making time for us, doctor. Was the entire examination conducted at your lab in Jackson, or was Gabby Petito's body shipped to another facility?
The examination was done entirely at our org in Teton County, Wyoming.
Anna Gregorio.
Gregorio. It's actually Ashley Banfield with News Nation. Doctor, thank you for taking the time today. Can I ask you if from the very beginning of your process, was it obvious that the cause, not the manner, that the cause was strangulation and that you just needed this time to prove it out? Or were you completely unaware from the beginning what the cause of death was for Gabby Petito and had to resolve through a number of puzzle-solving manners and other experts to arrive at that final cause determination?
In a situation like this, nothing is obvious. And so the cause of death required investigation.
We have a William Walkie.
Hey there, Dr. Blue. My name is Will. I'm from KHOL Jacksonville Community Radio here in Jackson. You're a small town coroner here in Western Wyoming. This case got so much national attention, as we can see right now. Can you speak on what it was like doing your job with such a big spotlight on you? Thanks.
Well, it was quite the media circus and continues to be. Unfortunately, this is only one of many deaths around the country of people who are involved in domestic violence. And it's unfortunate that these other deaths do not get as much coverage as this one. I'm assuming that because the deceased was a blogger, that this received more coverage than others. But there are a lot of both men and women who have lost their lives that aren't covered with this kind of media attention.
Francis DeFiore.
Yes, hello. This is Francis DeFiore from the Port Charlotte Sun. I just want to go back to my previous question, although I imagine your response. Is there anything you can tell us about how exactly determined it was a 3 to 4 week period before death?
I can't go into that kind of information at this time.
I understand. Thank you very much.
Why don't we take one more question then?
We have the Snack Squad.
Hey, this is Andy Mercado from Mercado Media. Could you go over the length of time the autopsy report took? And thank you for your time, Dr. Blue.
Well, the length of time was involved in the sense that we received a report from the investigating and examining forensic pathologist. We had a report done by our anthropologist, and we had toxicology studies that were done in addition to the report from the radiologic studies. So all these came together, and that's what took time for us to complete this investigation.
Hi, doctor. Could you speak to the state of decomposition, and did that at all hinder your investigation?
I can't comment on that.
Dr. Blue, would you like to take any more questions?
Unless there's other specific questions that haven't been answered already, why don't we close this? And thank you all very much for your participation. And I can tell you that I will not be answering any other detailed questions about the autopsy. As I said, state statute prevents us from doing that. So contacting me by email and phone is not going to reveal any additional information. But thank you for your time, and I appreciate your interest.
Dr. Blue, I have one more question. Is there a way to determine if this was accidental or deliberate?
You mean in the sense of a homicide?
Yes.
That would be up to law enforcement to make that determination.
Great, thank you.
Again, thank you all very much for your time.
All right, this is what we learned from that press conference held by the Teton County coroner in the state of Wyoming. Gabby Petito was strangled to death. We know the cause of death this coroner found was strangulation. We know the manner of death he found is homicide, meaning she died at the hands of someone else. Who that someone is up to law enforcement to determine. And you kept hearing the coroner deferring to this is a law enforcement investigation. He couldn't comment on a number of things. He said he knew by the state of her body that she was outside for 3 to 4 weeks in the wilderness. He would not comment if the place where her body was found was the place where she was killed. Again, he said that's an investigation, up to investigators to determine. He would not talk about Brian Laundrie potentially being a suspect. Again, that's up to law enforcement. But what we learned today was that Gabby Petito was strangled to death. That is how she lost her life. And we will have more in our next hour here of Court TV Live. Ashley Wilcott will be here next. That's all for me here at the desk. I'm Julie Grant. It's been great being with you.